There they are. Let me address this real quick and I'll get them on there. As you know, I did a 4-part series on this new guru named Todd Duell, D-U-E-L-L. Now, he just jumped up and just burned. Man, I mean, everybody just jumped on him thinking that he's the next Jesus Christ. So I was like, who is this guy? You know, he sure is making a lot of claims. And again, I work on a standard: proof of concept, proof of success. If you can't show me those two things, beat it, bump it on down. You don't have the answer. So I did 4 parts in video, and then I did one where I'm just like reading the record, just doing more investigative. I spent at least 40 hours of my own personal time. Nobody paid me to do this. Nobody even asked me to do this. I did this on my own volition. And I came to find out that the guy's just a flat out liar. That's all he does is lie. He's lied about everything. So whether his process works or not, I don't know. I don't have time to go vet that, go end up in tax court to find out if I'm going to win, if it actually works. But somebody who watched my video, this is what they texted me. There's the text. Okay. I don't want you to read it. I want you to get their phone number. It says, "Hi, Floyd. Happy New Year. Thank you for your 4-part series on Todd Duell. He took my friend for $18,500. He took my friend I swear, tell the truth, whole truth, nothing but the truth, so help me God. Just so you know, I'm on the up and up over here. We don't play around. We don't lie. We don't bullshit. All we're seeking is the truth." So he took my friend for $18,500, $10,000 for a complex trust, which is the complex irrevocable trust for the IRS, which is no difference from an irrevocable trust, folks. Okay, there's no difference. He just threw a complex on there to make you think that, oh my God, this thing is more difficult. Maybe I need some help.
So we're getting ready to get on to
Nope.
a live show.
You can buy the ebook for $49. You can buy the soft cover book for $99. You can go take a class.
So everybody, we are currently
everything you need to know about irrevocable trust.
We're currently going on with Fearless Floyd podcast right now. You guys will be able to listen in. If you guys want to watch the show, you can watch it, I believe, on Rumble and his YouTube channels if you guys want to come across. But this is the Fearless Floyd podcast, guys. We're going to do it jointly together right now.
I don't know what's wrong with that one. We're still having our Zoom meeting today at 4:30 Eastern. If you didn't get the email, it's because I ran out of emails for this month. Go to justicewithoutlimits.org. The link to join the Zoom today at 4:30 Eastern, 3:30 Central, 2:30 Mountain, 1:30 Pacific. The link to join is on the very front of the homepage, justicewithoutlimits.org. It's right above the survey. So if you didn't get an email, it's the same link as always, but I ran out of emails. So they'll reset on the 7th, January 7th, they'll reset and we'll have another, 40,000 emails or whatever that we can send out. But that's good that we're running out of emails because that means that we're growing. This last week was a little bit down. We've been getting between 600 and 900 new people that are joining the movement every single week for the last 6 weeks. This week was a little bit down. It was a little over 400. Still not a big deal. I think with the holidays and the new year and all of that, it just, information hasn't been getting out quite as much. But 400 is still nothing to shake a stick at. That's still a lot of people that are joining us. So very thankful for all of you guys. I can't hear what he's saying. Can you?
No, we're not on stage yet.
Oh, okay. So anyway, that's what's happening today. We're going to be going over on the Zoom. I want to go over some things that came to my mind about the Second Amendment. So I'm not going to talk about that publicly, but please join the Zoom if you can. It is a private Zoom, and so we all act accordingly, but it is regarding the Second Amendment. Also, we have Zetronics. We are an affiliate, an official verified affiliate with Zetronics. If you go to justicewithoutlimits.org/protection, or if you just go to the website, up in the menu, it'll say protection. You'll see some of the spy gear,
All right, we're coming on.
protection wear, and things that you can use to capture, have accountability. I don't know what's wrong with that one. Have accountability wherever you go, pretty much. So check that out. It's pretty cool. There's a lot of wearable devices for ladies. There's a wearable pendant that has a camera. It's both audio and visual recording devices. There's some spy cameras. There's a lot of really cool stuff that we can use to protect ourselves, which is part of the Second Amendment. So that's what I want to talk to you guys about on Zoom. But I'm going to stop talking because we're getting ready to go on here with Fearless Floyd.
Again, Fearless Floyd, if you guys want to watch it live, you can go to his YouTube channel or his Rumble channel. It's the Fearless Floyd Show. All right, guys, you're going to be able to hear him. You're not going to be able to see him unless you're on his channel.
And I say that, with all grace and humbleness, how these people are my personal heroes. I don't have to have them back on my show because it's not my category of what I really cover, but it's important to me as a human being. It's important to me as a society that we uncover all the fraud, the corruption, where there's zero accountability, and these people are just wantonly breaking the law. They are criminal organizations. They need to be stopped. We need to reorganize this country, our society, and how we govern ourselves. And with that, I'd like to bring on the Honorable Mr. Tanawa Downing and the beautiful, gorgeous, brilliant Jessica Saxton. How you doing, folks?
Afternoon, Mr. Floyd.
How you doing?
I'm doing fantastic. I am so happy to see you folks, especially sitting side by side. I really am. I'm impressed. I'm happy for you. And for those of you who have no idea who you are, what you're doing, y'all give us a little elevator pitch of who you are, how you got to from where you were to being on the front lines, addressing all these governmental officials and telling them the truth.
Let me go first.
Ladies first.
My name is Jessica Saxton. I'm a civil rights advocate and litigator. When I say litigator, I say that because I am litigating my own case. We are not attorneys. We do not represent anyone in any type of legal way. I got involved in this once I became aware of kidnapping under the color of law. That was because of my own personal case, but I wasn't willing to fight as hard as interesting. I wasn't willing to fight as hard as for myself as I was once I became aware that other people in my county and my state were going through the same thing. Some cases much more horrendous than my own children. So that's what sent me down this path. I met Tanawa in November. I started following him in November. We met in February of this year, and then I went public with everything in April. So that's why I'm here, fighting on behalf of the families, and every day is a battle. So your turn.
So my name is Tanawa Downing, and I'm a civil rights advocate and litigator. And so what I do is once again, I'm not an attorney, just like Jessica said, but attorneys go through what's called adjudicative law. They learn about the adjudication process. So all of the laws that they learn are ordinances, customs, statutes, and judge-made rulings. All the laws that remove freedom, because they're in the business of removing freedom. That's what they're trained to do, is remove someone's freedom. So that's what an attorney goes through. I went through what's called substantive law. All right, this is where people get this mixed up. I deal with the laws that set free. So all that I studied was the Constitution of the United States. I deal with law enforcement. I enforce laws as opposed to administer laws. Attorneys are administrative agents of the court, right? According to the corpus secundum, that's what they do. They deal with the courtroom. I deal with everything that's not the courtroom. I build cases. I collect evidence. I get affidavits. I provide services and notices. This is exactly what I'm trained to do. This is my job. This is my technical expertise. And the truth is that prosecuting attorneys and prosecutors should have my degree as opposed to what they have, because the big challenge is that if I'm trained to make a person into a criminal, I'm trained to look at this person and figure out how can I remove their freedom, then when someone walks into the room or into the courtroom, I can't look at them fairly and neutrally and unbiased, because all that I know how to do is make them into a criminal. So there's a technical expertise, a professional domain that's missing from every single courtroom, and that is the role of the of substantive law. So, that being said, I am litigating a very, very big case on behalf of people in the United States. I'm making it so that I can step in and act as a private attorney general to prosecute criminals that choose to act criminally. And that's a big part of, this work that Jessica and I are doing with providing these services, because, once we go out and we notify a public official and make them aware of crimes that are being committed, particularly crimes that are undermining the laws of the United States, as of that moment, they individually have a choice. Because if they choose to exercise power that they know is unlawful, despite being made aware of the criminal conditions, now they're knowingly and willingly committing a crime, and that's a whole different ballgame from just simply negligence. So once we make these public officials aware that there is a criminal condition that exists, and then and I bring that notice to them, then I am now in direct opposition with them. And so if they fail to take action as lawfully required to correct the unlawful acts, particularly of the people that work for them, then that means that they're sanctioning it, they're permitting it, and allowing it to continue. And once again, that's a whole different ballgame. So I will handle all of this all the way up until the time that we step into a courtroom. And once we step into a courtroom, I will need to hand off just like anyone else. I will need to hand off to someone that is going to prosecute this, unless we can't find anybody that will actually do that, right? And in order for that to happen, that person's going to have to step up, mitigate their culpability in the criminal conspiracy, acknowledge the fact that all of these convictions are unlawful and unconstitutional, and choose to do the right thing and notify their co-conspirators of their intent to no longer participate. And failure to do that means that I'm the only one that can do this. There isn't a single state attorney general here in the United States of America right now that can prosecute this lawfully, because every single one of them are opposing party as of this moment, because we provided them notice and given them opportunity to fix this. So I got into this about 9 years ago because I was on the other side. I spent many years working for government, building solutions and technology to protect government from the people. And about 9 years ago, God just kind of opened up my eyes and showed me that I was on the wrong side, doing the wrong thing. And that's when we decided that we're going to go into this full time. And I've been doing this nonstop. This one case, I've been building it for 9 years, and we're a lot closer to being done than I think anybody would ever believe. So it's been a real honor to serve people in the United States, and thank you so much.
Wow. Okay, so you have litigation pending. You've been working on this for 9 years. Explain to people what that looks like so they can wrap their head around on exactly the machinations of what you're doing. You're trying to accumulate affidavits. So explain to people about the suit pending in Washington State, what you're doing with that, where it's at as far as case status,
Okay.
and where you want to go with this.
Let me hit on the two and then on. Okay, so essentially the issue is, can a state be both accuser and judge in the same cause? That's really the heart of this issue. Can a state be both accuser and judge in the same cause? You see, when it comes to the indictment by a grand jury or the absence thereof, what happens is that the state becomes the accuser, because an agent of the state is bringing an accusation of you having committed a crime as a result of receiving information from a victim. Now the state becomes a party in the cause because one of their agents is now responsible to act as the victim to prosecute you for the alleged crime being committed. So in the case of a criminal matter, the issue is, can a state be both accuser and judge in the same cause? Can the body of men that make up the state be both accuser and also the judge, and be presumed to be neutral and unbiased to arbitrate the issue? And the answer is absolutely not. And that's actually codified in the Constitution of the United States. So we are relying upon a very, very particular provision of Article 3, where it says that anytime a state becomes a party in a cause, that the federal judicial authority of the union extends. That the federal judicial system must be the judge. This is the separation of powers that we're trying to illustrate, because the same body of men cannot be presumed to be neutral and biased to act as a judge against you. Now, what happens with information is a victim will call up the police and say, this happened to me. The police will then take that information without verifying it or validating it or giving the accused the right to confront the hearsay accusations against them. They'll reduce it to writing in the form of an affidavit, and they will submit it to a judge and ask that judge to determine whether or not there is probable cause to assume that a crime has been committed. But the problem is that the judge and the prosecutor both work for the same entity. They're part of the same body of men that make up the state, which just so happens to be the accusing party, the moving party in the case. So in these particular instances, this sets up what is called a trial by affidavit. And a trial by affidavit is what's also known as an irrebuttable presumption of guilt. An irrebuttable presumption of guilt is the presumption that you are guilty based upon the mere fact of having been accused of committing a crime. So if you are presumed guilty based upon the mere accusation of having committed a crime, this is an irrebuttable presumption of guilt. And the issue here is that your right to confront your accuser evaporates because you can't put the information on a stand and cross-examine it. So you've got confrontation clause issues, but more importantly, what happens now is that there is a shift in the burden of proof. Normally, the state must prove that you're guilty beyond a reasonable doubt. The burden of proof always resides upon the state, but not in an irrebuttable presumption of guilt. In this particular instance, the burden of proof shifts because you are already being treated as though you're guilty. The liberties are already being deprived of you. You're taken into jail. You don't have the right to use your property to generate revenue, to take care of your family, to live and be free. And all these things that the Constitution was designed to protect you from, the state no longer has to prove, but now you have to go out and collect evidence to prove that you're innocent. And that is a shift in the burden of proof. And according to Blackstone, this particular breakdown of due process occurs when the system focuses on speed and efficiency as opposed to established procedures and processes. We have a well-known, documented, verified, and actual breakdown due process because the system is looking at how many people they can get through. Now that's the criminal court. But ultimately, big picture is, what I'm doing is I'm showing the behavior of the judiciary. Because if the judge in a criminal matter is being taught to presume that you're guilty based upon an accusation of having committed a crime by one of their agents, then that judge is also acting in family court. And in family court, you have the same exact breakdown of due process. Because an agent of the state, being CPS, and don't kid yourself, CPS is absolutely an agent of the state because they are there to enforce the laws of the state. So when an agent of the state brings an accusation against you of you being unfit to be a parent, and then that judge presumes that you're unfit based upon the mere fact of having been accused of being unfit, now your liberties are being taken away. And now the burden of proof shifts. The state doesn't have to prove that you're unfit. You have to go out and collect evidence to prove that you're fit. This is a shift in the burden of proof. I can't show that it's a breakdown due process because Blackstone hasn't written about family court, but I can in criminal court. So the thing is that we're pointing at the judges and we're saying this is what the judges are being taught to do, to presume guilt as opposed to innocence, to immediately remove fundamental liberties without giving the accused the right to be able to confront those hearsay accusations against them. This is the behavior of the judiciary, and if it is a breakdown of due process in one, it must be a breakdown of due process in the other. Therefore, if the starting point is you must be innocent until proven guilty, then you must also be fit until proven unfit by the state. This is the case that we're bringing. Jessica?
I'm going to throw you a curveball.
Throw me a curveball. She's going to throw a curveball, Floyd.
Well, because
Okay.
this is the first time I ever thought about this when he was talking, but the speed and efficiency would be a fallacy because none of us here have ever experienced any type of speed and efficiency in the system through the court. So then why are they extending all of this? There has to be something for profit.
Well, it is for profit.
Well, I know, but,
It is.
but if they're trading this burden of proof, switching
Shifting,
the burden of
shifting.
proof, swifting the burden of proof, and then, but there's no speed, there's no efficiency.
Yeah, I mean,
How does it-
ultimately what it is they're just simply trying to get as many people through the system. You see, the big
But I
argument.
don't think it's through the system.
No,
I think
no.
it's into the system.
Absolutely,
and then they never
absolutely.
come out.
You know, so there's a few things. We hear arguments all the time that, oh, if we had to have everybody go through a jury trial, it would clog up the system and we'd never get anything done. And that is an absolute lie, right? It won't clog up the system. What it'll do is it will require government to determine what the cases that are necessary to be prosecuted. All of these victimless crimes they'll have to find an alternative solution to governmental or to societal problems. Isn't that the purpose of our government, is to come up with solutions to societal problems? The solution to societal problems of people not having enough money to take care of themselves, or not having enough food to eat, or having a breakdown of the family unit because we aren't preserving and making sacred the marriage and the institution, right? When we do that, then don't be surprised if we have these societal problems in place. So government can't blame the people for the societal issues. Government needs to come up with a solution for them, and the solution is not to immediately send people to prison or steal children from people. But I do want to say one other thing, Floyd. Never, ever, ever does a defendant ever have to prove that they are innocent or fit, right? It is always the state that must prove their case every single time. This is absolutely fundamental to our constitutional system, right? And so never, ever, ever does the defendant have to prove their case. Not only is that a violation of American constitutional law, but that is a violation of international human rights standards. Never, ever, ever does the defendant have to prove they're innocent, because the system is already arrayed against them. And it's well known. So
let me ask you a question, and it may or may not apply. I've never been through a child custody case, so I don't know what the machinations of that looks like legally. I've proven that a criminal judgment and sentence here in Texas, for sure, I don't know about other jurisdictions, but I've proven that under the Uniform Commercial Code, which is adopted by Texas, called the Texas Business Commerce Code, Section 7201, 7202 are about warehouse receipts. 202 gives you the exact terms and conditions which must be established within the warehouse receipt to make it a legitimate warehouse receipt. Now, is there a document in child custody similar to something like a judgment sentence in a criminal matter, which would order the child to be, put into a certain custody status, appointment of the attorney ad litem, et cetera, et cetera?
I don't know. Do you know?
So there has to be. I mean, in order for the state to take custody, there has to be that exchange.
Well, there's supposed to be. But we're running into situations every day where the children are removed by law enforcement before there was ever an order put before anywhere.
Right.
Or anyone with the authority to actually take the children. And one of the ways that they are identifying what child to take next is through the schools and truancy. I mean, we're dealing with cases all over the United States where the school is taking it upon themselves to remove children from healthy, fit, loving parents because the parent has two, or that the child has two unexcused absences. That is insanity. And you know what? This was brought to my attention just a few months ago out of East Tennessee, because that's where my case is. And so I had a lot of families that were contacting me, and they were like, my children were moved because of truancy. And here's the most important thing to remember is that most of these families that I've talked with were able to prove that their child was in school on the day that the school was saying that they were not there.
Oh, no.
And so they're falsifying the record through the education system to give a report to social services, who will then initiate the unlawful removal of the children. That is not something to just ignore. That is legal. It's unlawful.
It's fraud. It's an introduction of fraud into it.
But it's kidnapping. I mean, they're literally kidnapping these children, and they're so systematic about it. They're strategic about how they do it. But, we have a case in North Carolina right now where the mother lost her children 2 years ago. She was, her case for truancy was dismissed against her a year ago. She still has 3 of her children in CPS custody. One of those children I'm not going to talk too much about her personal case. Let's just say that North Carolina State's making a lot of money off of their children. And I would dare say that every single person that had a hand in the removal of those children and the continued isolation from those children and that mother, they should be tried for kidnapping. That's
Aggravated
where we're at.
kidnapping.
I mean,
Let me add to that. Not should, but what's important? Like, a lot of people don't realize that there is a far lower burden of proof for a public official in their criminal conduct, right?
Yeah.
A state has a much higher burden of proof to prove that the people are guilty of a crime, because they must show that we knowingly, willingly, and intentionally committed the criminal conduct. It's not the same for a public official. Public officials have got what is called a per se crime, right? Meaning that all we have to do is show that there was a lawful obligation, a constitutional obligation, and that they didn't fulfill it. And if we can show that there was a lawful obligation, they didn't fulfill it, they breached it, they broke the law, then by showing that there was an obligation, the willfulness, the knowledge, the intent comes from, the mens rea comes from the actual breach of obligation. Because every public official, when you enter into your office, you swear by oath or affirmation that you will support and defend the Constitution of the United States. That is a promise that you make for a future outcome. And when you fail to fulfill that promise, then the effect of the oath is that you've committed perjury and you've already implicitly invited punishment should you fail to fulfill the promise. That's why the burden of proof is much lower for public officials. We do not have to show that they knowingly and willingly and intentionally did it. All we have to show is that they had an obligation. So my point here is that if the obligation exists, that they are to preserve the family, right? The whole right of intimate association, 1987, Roberts versus United States, that the right to intimate association exists. The child has the right to have an intimate familial relationship with the parents without governmental interference. Then that means that government is obligated to protect the family. That's their obligation. They're there to protect it. Likewise, on the indictment by a grand jury, if no person is to be held to answer for a capital or otherwise serious crime unless on presentment or indictment of a grand jury, then the obligation exists. You cannot hold someone over for that offense without it. So by the breach of obligation, when the judge orders a person to be held for that offense without the grand jury, they've broken the law, they've broken the Constitution, they breached their obligation, and all we have to do is point and say, the Constitution says you had to do it, you promised to do it, now they're already guilty. So the burden of proof is much lower for public officials. But to go back to what Jessica was just saying, when the judge commits the crime of deprivation of rights under color of law, and then a sheriff deputy advances that deprivation by actually executing the removal of the child after the judge has already breached the obligation, and then they bring that child into a facility, and that facility then holds that child there. Every single person, willfully or negligently, it doesn't matter. Every single one of the people that is involved with committing or advancing the base crime is committing conspiracy by and between themselves and the initial offending individual, the judge. Every single one of them. Every single sheriff that is involved, every single CPS agent, the governor, the attorney general, every single person that is involved in that is now a part of the criminal conspiracy. And we don't have to prove that they intended to be. All we have to do is show that they advanced the base crime of deprivation of rights under color of law and that they are under oath to support and defend the Constitution of the United States. That's why these notices are so important, you guys, is because when we go out, whether you like it or not, whether you believe that this is going to work or not is irrelevant. I believe in this. I know it's going to work. My faith is enough to continue to do what I'm doing, and I'm going to continue to do it every single day because I know that this is going to work. But when we go to a city council member, and that city council member says, this has nothing to do with me, right? This has nothing to do with me. Hell, this isn't even part of my city, right? What you're talking about, right? You're bringing in an accusation from a person from a completely different city. The answer is that you are now made aware of the criminal conditions. You pay people to commit these crimes. And if you continue to pay them even one more time, you're now bound into this criminal conspiracy. You are now a part of it because you're paying for these crimes to be committed. whether it's law enforcement, whether it's the sheriff's department, whether it is the county courtroom, which is the resources used to facilitate the abridgment of the constitutional obligation, whether it's the jail, whether it is the CPS facility, the juvenile justice center, whether it's, it doesn't matter. Every one of these public officials have got their hands on this, and every single one of them is a member of this criminal conspiracy once made aware. Right? Once made aware, they have to make a decision. Am I going to continue to do it or not? But we don't even have to make them aware. We're just simply doing this because this is the easiest, peaceful way to reconcile this, is to find those people who are going to be willing to support the Constitution and make them have to do it. By either one, you are part of the criminal conspiracy, or two, you mitigate your culpability. And I just want to finish with this. Once made aware that you are a member of a criminal conspiracy to undermine the laws of the United States, there's two things that every single public official, every one of these people were provided notice to, two things that they must do. The first is they must notify the authorities of the crimes being committed, right? Of course, you got to call the police and let the police know, hey, I'm aware of a crime. If you don't call the police, and it's not police, but I'm simply using this as an example for you. If you know that a crime is being committed, and you choose to do nothing about it, you ignore that, right? You may as well be the person pulling that trigger because you knew about it and you continued to permit it to happen. With these city council, county commissioners, attorney generals, senators, congressmen, with them, the first thing that they must do is you better call the police and let them know that crimes are being committed. That's the first thing that you have to do. In the case of deprivation of rights under color of law, the only agency that can investigate that is the FBI. So if you, city council or county commissioner, if you have not called the FBI to report this crime after we provided notice to you over the 108 counties and cities we've done, then you have not taken the first step to mitigate your culpability, and you are still a member of that criminal conspiracy, period. Willfully or negligently. The second thing you have to do is you must notify your co-conspirators of your intent to no longer participate, but that must be done by affirmative action. In other words, you must show us that you did something. There must be a public action, a public notice. So for a judge, let's take the indictment issue. For a judge, if you want to notify your co-conspirators of your intent to no longer participate, you're going to have to say to that prosecuting attorney, I'm dismissing this case until you bring an indictment by a grand jury as required by the Constitution. That would be notifying your co-conspirator of your intent to no longer participate. If the prosecuting attorney is bringing the incorrect charge and instrument, that's fine, judge, but you are establishing a conspiracy the moment you hold someone over by relying upon the prosecutor who abused their power by relying upon an imperial state statute to abridge a constitutional obligation. For the prosecuting attorney, what you need to do is you need to say, state legislature, I don't give a shit if you create a law that tells me that I can bring information. I'm going to follow the Constitution. You're going to be notifying your co-conspirators of your intent to no longer participate, but you have to do that, prosecutor. You have to say to the state, I cannot enforce an imperial state law that allows me or directs me to violate the Constitution of the United States. That would be how you would mitigate it, Mr. Prosecutor. And for all of you legislative officials, city council, county commissioners, senators, congressmen, for all of you, what you have to do is you have to say, I'm not going to pay you guys to commit these crimes anymore, right? Because I'm responsible for paying you. So you either obey the law, the supreme law of the land, or you're not going to get paid for the work that you do because I can't pay you anymore. That's how the three-branch government would have to mitigate their culpability. And unfortunately, Floyd, we have seen none of that yet. Not one of these branches is doing what's necessary to mitigate their culpability, which means that we've got probably at this point tens of thousands of public officials who have been notified, made aware of these criminal conditions, and have chosen to willfully, not negligently, willfully continue to progress into the criminal conditions that we've outlined before them. Very dangerous situation for them.
It's insane what we've allowed our society to digress to. Now, let me ask you this, because I was going somewhere with this about the whole monetization of CPS and child custody. Jessica mentioned North Carolina, that children are very valuable to the system. I believe it was probably about 2 or 3 years ago, somebody sent me the specifics on North Carolina, and I'm ballparking it here, but roughly about $96,000 per child. goes into the system, comes back from federal funding. Most people don't realize when a child gets taken into CPS that they get federal funding per that child. And it's just this crazy, insane money racket that's going on. The reason I asked about if there was a judgment and sentence or some type of judgmental order or decree in the child custody cases or probate is because in a criminal matter, we know that they're issuing the bonds, the GSA bonds, the payment performance, those bonds. If you're not familiar with them, there's GSA, General Services Administration, standard forms and optional forms. And we're talking about the 24, 25, 25A, 28, which is the affidavit of individual surety. And then you can go on to the 34 and 35, which are annual, and then jump up to the 273, 274, 275. And then you can go up to the 14, 14, 14, 15, 14, 16, and 14, 18 of those series, and then the OF 90 and OF 91. So we know they're doing that in the criminal matters. And the reason I say this is because I have this book here, and I've been sitting on this book for quite a while. And I've read parts of it. I haven't read the cover to cover yet, but whenever I see warehouse receipt, it piques my interest. And the reason it does is because when I was behind bars and I was studying in the law library, and I had pretty much exhausted every avenue available to me through the legal channels, I kept reading over and over and all this new material and all this, sovereign citizen redemption manual, cracking the code, all that. Gene Keating's prison treatise kept telling me I was in warehouse. So I opened up the Texas Business Commerce Code. I started going through the table of contents to find out what this whole thing was about, because the UCC, and I get to warehouse receipts, Section 7. So I started reading it. And when I read 7202, I was like, holy crap, is this my judgment and sentence? So the next day I brought my judgment and sentence, put them side by side, went down the list, sat back, went, wow, that's a thing. This is a real thing that they have me in here. And it all starts is, what do? They charge you with an offense. So you're supposed to go in and settle the matter. Well, it goes to the grand jury. What does the grand jury do? They look at all the reasonable articulable suspicion that a crime may have been committed, any witnesses or the prosecutor presenting their case, and they either no bill you or true bill you. That means they gave you a bill. Now you have to settle the bill, right?
So it gets easier than that. But let me just start by saying that the way their system works is if you choose to violate the law, you incur a debt that is owed to society, to which you are charged, called to account, so you can pay the debt. These are all accounting terms. So it is a debt that's owed to society. A debt that is owed to society is what the system claims that you've done. If you violate the law, you incur a debt. It is a debt-based system. Now, slavery, right? The history of slavery has always been, if you owe a debt to someone and you can't pay that debt, you could sell yourself into slavery to settle the debt. It was a feasible alternative for debt management. That is the history of all slavery that exists, including our justice system. You see, justice here in America is not about morality. It is about revenue. It's about a business. It is about debt. It is a debt-based system. And so, when you look at what you just said, like the indictment is a bill of indictment. So you have to get billed, right, in order to have a debt, in order to have a charge to your account. Someone must bill you in the economic system. So if I'm going to buy something from a store, I'm going to go in, I'm going to say, I want that right there. And they're going to say, okay, it's $3,000. Here's the bill. And I'm going to take that bill, and then they're going to charge my account. And now I got to pay that debt for the item that I purchased, right? That is the debt-based system that exists. That's why this whole argument of the absence of the indictment by a grand jury is there is no bill. When did you bill me for the charge? And in accounting, if you don't bill someone before you charge them, that's accounting fraud. You
Right.
must always bill someone's account before you can charge that account. And if you charge someone without billing them first, that debt is fraudulent. It derives from a forensic accounting flaw. So, but think about this, right? Think about this. The history of our system. Justice has always been about slavery ever since our founding. Even our founders. If you look at the Constitution, Article 4 says that when a fugitive flees from one state to another, that state is to give them up and return them to the original state. That fugitive was not referring to a criminal. That fugitive was referring to a slave because of the Fugitive Slave Act. A fugitive is a slave, and a slave is a fugitive. These terms are synonymous with one another. But then you fast forward to the 13th Amendment. We fight a war, lose 600,000 of our people fighting in this institution, or fighting against this institution that we called slavery, and we thought we outlawed it. And then we created an amendment to the Constitution that says, yes, slavery doesn't exist anymore. The 13th Amendment, right? The problem is that we allowed for the slave owners to put their hands into the establishment or creation of that law, because guess what? The 13th Amendment, surprise, surprise, doesn't say that you can't have slavery. What it says is neither slavery nor involuntary servitude shall exist except as a punishment for crime. And the moment you say except, it means that you can have slavery, but it must be a punishment for crime. So we can enslave people. We can force them into involuntary servitude, right? And as long as it is a punishment for a crime. So in other words, a criminal is a slave, and a slave is a criminal under our law. But the problem is that the 13th Amendment, prior to that, slavery and the slavery institution was a private institution. People owned the slaves. But the moment that the 13th Amendment was ratified, who became the slave owner? The state. The state became the slave owner. As of that moment, the state became the slave owner. So now the state is in the business, because they're the ones that are profiting off of the involuntary servitude of the criminals that they've now forced into involuntary servitude under this guise of justice. The 13th Amendment didn't remove slavery. What it did is it retitled it justice, and they traded it from a private institution to a public institution, and now the states are making tens of billions of dollars off the forced involuntary servitude of the weakest, most vulnerable in our society by simply labeling them a criminal.
So
This is all about slavery. Every bit of this is about slavery. And slavery is an economic issue that derives from a debt that is owed to someone. Now society, now the state says, you owe me a debt, Mr. Floyd. You owe me a debt. And since you can't pay that debt, I'm going to require you to sell yourself into slavery through a contract, and you're going to go into my business working in involuntary servitude for me, for the direct benefit of me and this institution. The slavery institution is owned by the states. The slaves are the prisoners. The prisoners are selling themselves into slavery because they are poor and they can't afford to be able to buy themselves out of it, or bond themselves, or bail themselves out. If you can't bail out of jail, you have an 80% likelihood of going to prison. If you can bail yourself out, you've got an 80% likelihood of not going to prison. Therefore, only the poor go to prison. The rich don't. Go ahead.
Well, it's the same thing with, I am being treated as a criminal, but I'm not behind bars.
Absolutely.
But so all of us that are out here fighting, and we've had our children that are removed from us, but yet we're still in this slave society.
Think about chattel slavery, the history behind it. What's one of the first things that they did? They took the male out of the household. Why? Because it reduced the mother into a lower socioeconomic status. It put the children into a lower socioeconomic status. It fed into chattel slavery, right? What do? After that, then you'll remove the mother, because any fearful slave, any child that is afraid and grows up with that fear is going to be more receptive to the requirements of the slave owner. They're going to be more compliant with the slave owner. This is what they're doing, the breakdown, destruction of family. What we're seeing right now is not an inconsequential effect of a just and moral system. It's actually intended to proliferate and advance this institution. They're taking your children, right? They're breaking the family down so that they can have more compliant slaves that are going to feed into their system. Today, we got 12 million children in the CPS system. Statistically, 10 million of them are going to end up in prison over their lifetime, right? Because 80% of all children that grow up without mother and father don't know how to live within a society, therefore they will end up in prison. So in one generation, we can see 10 million more prisoners feeding into the system, and those prisoners are your children. Your children today. That's why we're fighting for these prisoners now. That's why we're saying, what about these prisoners today, who one generation ago was part of that breakdown and fracturing and destruction of the family then? What about those children, right? Who you now point at and say, oh, they're just a criminal. They deserve to be in prison and enslaved and forced into military servitude of the state institution. No, man, they were children one generation ago that was already broken down, fractured, and destroyed. We got to recognize the correlation between the breakdown, destruction of the familial unit, the CPS system, and mass incarceration phenomenon. Today we got 16 times more prisoners than the next closest industrial nation, and I swear, statistically, one generation, 20 years from now, we're going to go from 16 times to 58 times if we don't stop this monster in its tracks.
It's crazy. All right, so I'm going somewhere with this.
Yep.
So bear with me.
I apologize. There.
No, that's all right. I love hearing you speak because you're just a wealth of knowledge. Again, you're unsung heroes here in the United States. I'm telling you. Congress, President, they should all honor you for what you're doing, what you're sacrificing. I'll get into the whole child thing in a minute. Now, if there is a document issued by the family court, probate court, whoever's handling that, and it is a warehouse receipt, it has all the machinations required for a warehouse receipt. Now, I want you to hear this. This is from the book, Modern Banking, Commercial and Credit Paper in 5 parts. This is volume 1 of 5 by Frederick Silver. This is the section of commercial banking credits, bank acceptances secured by warehouse receipts. General statutory provisions, acceptances by member banks. We all know what member banks are. Any member bank may accept drafts or bills of exchange drawn upon it, which are secured at the time of acceptance by a warehouse receipt or other such document conveying or securing title covering readily marketable staples. Opinions of counsel in rulings relating to bank acceptances secured by warehouse receipts, eligible security. Warehouse receipts required to be issued by warehouses independent of the borrower. Warehouse receipts offered as security for bills accepted by member banks must be issued by warehouses which are independent of the borrower. Where a corporation is formed as a subterfuge for the purpose of evading the spirit of the board's ruling, this fact should be taken into consideration by a member bank accepting the bill and by the Federal Reserve Bank to which it is offered for a discount. So basically what this is stating is, as my case, and I've discovered this, that my then trial judge, Mark Kent Ellis, created a business entity called County of Harris, Room 351, registered in Dun & Bradstreet. I have the background business report for that. It shows that he is the agent for that particular entity. And we know that they've issued bonds, and that's the entity that's doing it. So what he has done is he's created an entity that's not separate from him or the county or the state that are monetizing it. So this is an illegal act. Are they issuing bills of exchange on those bonds that they have created? I don't know. But what I do see, what this is telling me, that because I have this bond issued, that I can issue a bill of exchange using that warehouse receipt as the collateral. So I'm going to dive into this more. I'm actually going to do a show on all this. I'm going to go through here, break down all the Black's Law dictionaries, definitions of each of these words so people have an understanding of what a bill actually is, et cetera, et cetera.
Yeah.
So I'm wondering if this would apply to the same parameters, because we know all the courts, doesn't matter what they label them, are commercial courts masquerading as whatever they've labeled it, using civil rules and procedure. So what do you think about that analogy, that theory?
So part of my oral arguments to the Supreme Court is this. Our founders and forefathers who framed our Constitution were simple yet wise men. They weren't establishing complex principles or elaborate institutions to which only men of rich or educated or noble statuses could understand. You see, they were simply trying to create a legal accounting system which adequately and fairly reconciled the debt owed to society. If you choose to violate the law, you incur a debt to which you are charged, called to account, so you can pay the debt. These are all very simple accounting terms. Now, the way that debt normally works is, if I want to purchase something from a store, a bill is first generated, which I sign and accept. Then my account is charged, and I incur debt to which I then have to pay. This is a very simple method for transactions to which anyone can understand. However, if the store charges a person's account without billing them first, that is called fraud. You must always bill before a charge is generated. Now, how all this applies to this case is that an indictment is called a bill. So absent an indictment, people are being charged fraudulently because they're not being billed first. Understanding this now, anyone who claims that a bill of indictment is not first needed before charging someone's account doesn't understand the basic principles and practices of the system in which they're dealing with. As a result of this very basic, fundamental flaw in our nation's legal accounting system being ignored, millions of United States citizens have incurred illegal and fraudulent debt. America must address this flaw in our nation's legal accounting system. So my point is that when you look at the process for accounting, because they call this an accounting-based system, that debt that the state has incurred is fraudulent because, according to the Constitution of the United States of America, Article 1, all debt against the people must originate from the legislative branch. Neither the executive nor the judicial branch have the constituted authority to be able to create a debt against the people. And in a courtroom, all three branches of government are represented. You have the prosecutor, who represents the executive branch, the judge, who represents the judicial branch, and the jury, who represents the legislative branch. So that's why the bill must come from the people, because according to the Constitution, all debt must be incurred from the legislative branch. So when there is not a jury that creates a bill of indictment, then that means that the debt is fraudulent because it's originating from a branch of government that does not have the constituted authority to be able to create the debt. If the prosecutor creates the debt, that is fraudulent and unconstitutional because the debt must originate from the legislative branch. If the judge creates the debt, such as in child support, when the judge creates the debt against you, that is a branch of government that does not have the constituted authority to be able to create the debt against you. That's why the 7th Amendment says that in any matter over $20, right, that must go in front of a jury. Because the jury is the legislative branch in the courtroom. Absent a jury, a branch of government is now creating a debt or a tax against the people, and that is absolutely unconstitutional. So the bill of indictment must originate from the legislative branch. If you are going to bill the people of the United States a debt, that debt, according to the Constitution, must originate from out of Article 1. And if there's not a jury involved to, 1, create the bill, and 2, confirm the debt is valid, it is originating from a branch of government that does not have the constituted authority to be able to do it.
So are you saying that child support is an illegal tax?
100%. But not illegal, unconstitutional.
Unconstitutional.
Right. There's a difference between lawful and legal. We all understand that. Legal is the parameters in which the judge operates in. But just because it's legal doesn't make it lawful. There must be a law to make it full of law. And when the law says that the legislative branch must create the debt against the people, and then the judges say, oh yeah, we can do it. What they're doing is legal, right? But it's not lawful. And legal does not trump or does not supersede law. So what is lawful is what's pertaining. What is legal is the world that we live in that is unlawful.
And sometimes what is legal is sedition.
Well, most of the time, what is legal is going to be sedition, because the parameters of the system that they've established is that judges make the law here in America, and that also is a separation of powers issue, because only the legislative branch can create law. The judicial branch can only create rulings, and rulings is not law. Rulings don't affect me. I give a shit about what you legally say, judge, because your legal is contrary to the Constitution, and that's all that affects me. That's all that I have to abide by is the law.
But
I'm bound to the law, not to your ruling.
But if these lower states create a law for the inferior courts, and that law is causing disaffection to the United States, then that is...
So sedition is the basis of treason, right? Sedition. But sedition, the definition of sedition is, take notes, guys, that it is the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. So if you speak or write words that's intended to cause disaffection to the Constitution, so you can change it in a manner other than what is lawful in changing it, you just committed a seditious act.
So for the people that are in court, and you said such as law established, can we substitute that with such as an order established?
Well, think about it. The speaking or writing of words. Who speaks a seditious law? That would be the legislature. Who writes a seditious law? That would be a judge, right? Because only the legislative branch, and according to the Constitution, the very, very first provision of our Constitution says all legislative power is vested in a Congress of the United States consisting of a Senate and a House of Representatives. The very, very first thought that our founders put into the Constitution was to say that only Congress of the United States can amend the Constitution of the United States, right? Can create legislation. All legislative power. No other branch of government has the power to make law, because the very first thought of our founders' forefathers was all legislative power is vested in Congress of the United States, consisting of a Senate and House of Representatives. So when a state legislature speaks a law that is intended to get the people of the state of Washington to not believe in the Constitution of the United States, and then they're changing it in a manner other than the way it's lawful, that's sedition. When a judge, such as the Supreme Court of the United States, when they come out and say, oh, state of California, you don't have to do what the Constitution of the United States of America, and they write that out in a ruling and then direct all the states that you don't have to follow the Constitution of the United States, such as they did in 1884 in the Hurtado case that allegedly removed the requirement or the restriction for the grand jury against the states. When they did that, that was a seditious ruling done by traitors to this nation who overstepped the separation of powers, decided they were going to legislate from the bench, and that is unconstitutional. Doesn't matter if you're a judge. If you breach the Constitution, you break the Constitution, you're nothing but a criminal.
What about contempt of court? Is that a judge just making a law?
Contempt of court is another interesting one, because contempt of court, who is the offended party? Is it not the judge that's saying, oh, you didn't obey my order? Well, judge, how can you be both accuser and judge in the same cause? You can't, judge. You can't. Because the maximum of law is that no man can be judge of his own cause.
And so what about for those of us who have proven that a judge is disqualified, and then we file the motion for disqualification or removal or recusal, and then they hear the same case? Is that... So recusal is interesting because recusal is supposed to be the good behavior. It's supposed to be honor. Without honor, we don't have a judiciary. If we can't have honorable people act as judges, and remember, Justice Hugo Black stated in 1960, honorable men honor the law. If you don't honor the law, and you decide that you're going to not do what the law requires or restricts you from doing, right? That's a criminal. That's not an honorable person. And as of today, every single one of these judges that we're encountering are all criminals, because the definition of a criminal is one who transgresses the law. So if you transgress a law, you're a criminal. But what's really, really important here that everybody understands in what I'm doing and Jessica's doing here, I'm not saying that any one of these people are innocent. I don't know if they're innocent. In fact, a lot of them are probably guilty of whatever it is they allegedly committed. But what I am saying is that they're not guilty, because guilt is a process.
And you must follow that process. And if you don't, there cannot be guilt. And this is codified even in our own scripture, where Paul comes out and says, where there is unlawfulness, there cannot be guilt. Because government cannot act unlawfully and then secure guilty decision because you didn't act lawfully. You acted legally perhaps, but you acted unlawfully. There's a difference between legal and lawful. We're heading down the path of lawfulness. This is what the law states. You judge, you senator, you prosecutor are clearly operating outside of the law, which is unlawful. You can bring your legal bullshit to me all day long, but the law is what compels me, right, and binds you. And if you're not going to obey the law, then you've acted unlawfully, and that means that anything that you have done, government, is unlawful. Because nothing that you can do can become lawful if what you are doing is unlawful. If government commits a crime in the pursuance of an outcome, that outcome will always be criminal because of the per se crime. Because judges and public officials have a much lower burden of proof. All we got to do is show the law restricted you and you didn't follow the restriction. Therefore, you've acted outside of your restriction, and that means whatever you produced is void, wholly without force or effect, because it's without law. It's unlawful.
And that's what we're doing nationwide, is switching the mindset from we are taking the defensive side to now we're putting the state in a state of defense and we're taking the offensive side.
Yeah.
Correct?
Yeah, so there's, in sports, the best position to be in is always offense. Right? If you're on offense, you're going to win. You're going to score. If you're on defense, then the other team's going to score. You don't want to be on defense. So government wins when the people are on defense. The people win when the people are on offense, right? And the government can't win in a position of defense because their crimes are per se, right? If I can point out that you have committed a crime, government, if you've acted unlawfully, government, then you're on defense, and there is no right to self-defense for public officials. No public official can say, oh, I didn't know that I was breaking the Constitution, or, oh, nobody told me that, or, oh, the Supreme Court of the United States said I can break the Constitution. No, that's not an argument. There's no right to self-defense for a breach of a constitutional obligation. The Constitution creates the obligations. Government, you got to follow them. And if you don't, then what you've done is unconstitutional. Period. It doesn't matter. There is no justifying your behavior. There's no right to self-defense. So the point is that what we're doing is we, the people, what I'm doing is I'm trying to get everybody to go on offense. Stop defending yourself. There's nothing to defend, right? When they accuse you of whatever alleged crime they accused you of, guess what? They committed a crime when the state took action in a case in which the state doesn't have jurisdiction. Because no man can be judged in his own cause. The state can't be both accuser and judge in the same cause. That's the very first step. Did the state have the right to be able to remove your children? The answer is no. Because the state can't be both accuser and judge in the same cause. Did the state have the right to adjudicate your criminal matter? The answer is no. Because the state can't be both accuser and judge in the same cause. If we litigate this one question, this one issue, then guess what? By litigating that, everything after it becomes void. Everything. We got people out here that are talking about how the arrest was brutal. We got people out here talking about how the prosecutor hid evidence, or the prosecutor's biased, or the judge is malicious, or or the sentencing was excessive, or the fines were obscene. Whatever it might be, we have a whole process that exists, and we have people that are arguing different points of this process. We have people that are talking about the conditions within the prison. Each one of those is something that happened after the question, did the state have the authority to do what they did? Because if that is a no, then anything that was done after that point is void. It doesn't matter. So what I've been trying to do, and what I hope that will be successful in soon, is by telling everybody, stop defending yourself and go on offense. Did the state or did government break the law at any point in time in the adjudication process? And the answer is yes. When the state took action in a case in which the state did not have jurisdiction to do so, right? The moment that the state became an accuser against you and brought an accusation through one of its agents against you, that state lost its authority. That state lost its authority to be able to oversee that case. Period. And so if we can remove or question the jurisdiction, we can address this jurisdictional issue, that the state doesn't have jurisdiction to oversee its own case, then by doing so, all of the stuff that happened after that is all void, as though it never even existed. Because no court can obtain jurisdiction when it lacks jurisdiction. No court can make a valid judgment if that judgment derives from an unconstitutional act. So guys, this includes an adoption. Because if your child was adopted out, secondarily to the state bringing accusation against you to remove the child, that adoption transpired as a result of the initial breach of obligation. The state didn't have the authority to do it. So even if your child is adopted, we can still get them back. Yeah. That's also one of the reasons why my affidavits, the federal affidavits, the ones that you guys would download from justicewithoutlimits.org, it does not call a judge out. It doesn't mention their official capacity. If you were to read my affidavits, it says a person portraying themselves as a prosecuting attorney, or a person portraying themselves as a judicial officer, or a person portraying themselves as a law enforcement officer. I don't call them out by their official capacity because there isn't one. Because if the state does not have the authority to speak the law and administer justice when the state itself is a party in the cause, that wasn't a judge. Because in order for that judge to exist, that court must have jurisdiction. In order for that police to exist, they must have jurisdiction. And if they don't, that wasn't a judge. That was a person portraying themselves as a judge. That was a person portraying themselves as a prosecuting attorney, which means that is no different than any other person. And now we have eliminated all the immunity issues that we might experience if we called them out in their official capacity. There is no official capacity. My affidavits will not allow for official capacity because that's not a judge. That's a person masquerading himself as a judge legally, but not lawfully.
Let me ask you this. You've been all over the country, probably all 50 states, I would imagine. If not, definitely 48.
All 48.
48. We've been to lower 48. We haven't done Alaska White yet. We're waiting for some donors to be able to make that happen. That would be an expense that we can't bear.
Hey, can we talk about these maps for a second?
Oh, sure. Yeah, let me pull them back up. Sorry, I just dumped them.
So for the other individuals watching, if you go to justicewithoutlimits.org and scroll all the way to the bottom of the home page, there's 2 interactive maps. And this is the numbers from the reports regarding the family court survey. And it's interesting because the map on the left, those are the actual numbers. So you can scroll over each state and you can see the numbers of reports that have been gathered. So like from Texas, you have 133, California, 146. Can you scroll, Oregon, 48. Can you scroll over Florida? Florida has 240 reports. So this is nationwide. You can go over and find out how many reports. Tennessee, 129. Find out how many reports have been submitted in your state. That is still open. The survey is still open. The right map, the map on the right, it's interesting because it's all a heat map, guys. So when you look at it, it's red to light yellow. The heat map on the right is a density index. It's based on the per capita of individuals in the state. So Florida has the most reports at over 200, almost 250. But when you look at the heat map, the density index, West Virginia, and what is that? Is that Montana? West Virginia and Montana are actually the hottest states. Those are the most red states as far as the number of reports per capita. So it's really interesting. Just go take a look at it because it'll give you a different perspective as to where some of the hot spots are. California, you would think that California is an absolute hot spot, right? On the density index, it's very low. It's a light yellow color when you're looking at the heat map. So it's just something to think about when you're thinking about Florida's a hot spot, Texas is a hot spot, California. the entire United States.
And this is for the removal of children. It's not indictment issue. It's not criminal. This is family court issue.
Just for family court. Yep. So it's interesting, when Tana was talking about switching from that defensive versus offensive mindset, I have been in court since January of 2022. Weeks worth of adjudication and being in the presence of this judge and whatever. When I switched my mindset from defending myself to moving into an offensive position and putting the judge on notice and saying, no, judge, you are disqualified. You have a mandatory self-executing,
non-waivable, self-executing.
Yeah, duty to recuse yourself. That was the first time that I actually won in court. And I won even after she denied it. She denied my motion for recusal. And I stood up and I said, Judge, you cannot move forward according to Rule, it's Supreme Court Rule 10b. You cannot move forward until you write it out on paper and file that denial with the clerk of court. And she said, Ms. Saxton, you're exactly right. And she left. Came back in, she proceeded to move forward, and I invoked the interlocutory appeal now in Tennessee in order to take that to an appellate court, her denial for recusal. She had to sign an order saying that she, in the inferior court, allowed for me to file an interlocutory appeal. She filed that order on December 15th, and so she allowed it. That's the first time, after I moved into an offensive position, that's the first time that I've ever won in court since 2022.
Can you walk us through some of this that he's scrolling through? Could you take us back to the download page there, Floyd?
The docs.
Yeah, the docs. Yeah. Explain what we got here to his audience, please.
Okay, so the county service scripts, you have part 1 and part 2. When Tana and I go to the county commissioner meetings, I used to do part 1. Now he's doing part 1 and I'm doing part 2. But these are 2 scripts. The first part 1, that goes along with the public notice. This is regarding the 5th Amendment and the indictment issue. We're putting that on the record along with the emolument violation and paying public officials to commit crimes. The second, which is part 2 of the service, that's where we are serving the county level affidavits to the county commissioners, letting them know that there are agents within their county that are committing these crimes against families. There's 2 affidavits there, one for families and one for indictment issues. So that's the script. If you want to go out and serve your county, we offer training every Sunday. We're going to get started here in just a few hours. Every Sunday at 4:30, come on to the Zoom. We break out into some breakout rooms. You can go over the script. We have people that are there to help you that are, have already been over the script multiple times. The script is there. It's a 3-minute script. You can read it. One of the reasons why I ask people to start serving their county commissioners or state councils along with us was because I noticed that many of the families, or even the people that are in criminal court, they have been deprived of everything. They lost their children, the court has taken all of their money, and so they're left to represent themselves. If you look at the way that a county commissioner or city council arena is set up, it's set up the very same way that a court is. So when you walk in, you have a podium and you have the judge. Same thing with county commissioners. You have a podium and you have the county commissioners. So I wanted to start giving people the power and the reminder that they are the authority. So when you go into these public meetings, the county commissioner meetings, and sometimes they're called a county commissioner court, you go in and you are speaking with authority. So I wanted to have people start practicing speaking in somewhat of a anxiety driven environment, and it's proven to be very effective. Now the people that have served their county commissioners multiple times are saying, when I went to court, it's like a walk in the park. It was the same exact setup. I knew exactly what I was doing. I felt the authority. I felt the way that I was empowered based off of putting their county commissioners on notice. What Floyd is looking at now, this is the 6-page notice that you would put onto the record. And this is what Tanawa has written, and he's gone into very much detail about the accountable how the county commissioners and city council are actually held accountable if they continue to pay for the deprivation of rights that are occurring in their county.
So there's a 2-page script that you read, and you'll read it to them. It's much more broad, and then at the end of it, it says, I have a notice I want to put on the record. That's this notice. This kind of sums it up, but as I stated in our Birmingham service, just because they don't read it doesn't mitigate their liability within within the matter, right? And that's an important thing to note is that a lot of people say, oh, they don't even understand what you're saying. I don't care. That's not my problem.
Yeah.
I don't have to make sure that they comprehend or understand what I'm saying. I'm just putting it on the record in a public meeting on the public record. And if you choose to not understand what I'm saying, that doesn't mitigate your culpability. A lot of these people will open up newspapers or look away or look at their phone as if they think that that's plausible deniability. It's not. Once it's on the public record, it doesn't matter whether you ignored it or not. We brought it to your attention because, once again, it doesn't matter whether you know that you're breaking the Constitution. We don't have to prove that you knowingly committed the crime because your knowledge drives from promise you make. I'm putting it on the record, and if you guys want to ignore it and claim plausible deniability, that's perfectly fine. Mens rea is established through your oath.
So, on your journey across the lower 48, are there any jurisdictions that are even close to seeing things your way?
So I'm going to say that right now, we are close. We are, but we're not seeing the change yet. We're just seeing a lot of nervous people.
Yeah, but we do have some individuals that are coming to us asking us to serve their county, people that are sitting on the county commissioners.
Yeah,
And they're asking
Really?
us, yeah, they're asking us, they're saying, look, I know that the rest of my colleagues are criminal. I want you to come and serve us and serve me so that I will have to report these crimes that, you know, the judges and sheriff and whatever are committing, but they don't know who these people are. So
we've got some attorneys too.
We spoke with
Heck,
the former judge.
we just had a judge this week
Sure
that
did.
said we're absolutely right.
Yeah.
You know, so
Yeah.
listen, what we're doing, it is working, everybody. It's working. It might be slow, but it's working. I mean, we're dealing with the most powerful narcissist known to mankind. This was the biggest bully that humanity has ever seen, known as justice. This lie. It's not justice, it's slavery, right? I mean, this thing that we call good is actually enslaving the people of the United States. It's an evil institution. Guys, we're not going to fix this overnight. But we have to have perseverance. That's why I say that my faith is enough. I'm going to go out here because I believe in it. I know it's going to work. It's going to take a little while. And I know I've said numerous times that, oh yeah, we're going to be done by a certain date. That's also why I quit doing it, is because my work is finishing it isn't dependent upon me. Finishing it is dependent upon the actions of someone else. I can't predict when they're going to do what they have to do, but I can promise you that they're going to do what they have to do because I'm going to keep on doing my work until such time as we get it done. We're going to get it done. We're seeing change, but I think that the real change is that we're seeing a lot of nervous people, a lot of public officials that are getting really, really nervous right now because there's a lot of people that are hearing about the things we're saying, and it is absolutely true, and we know that it's true because when the people of the United States are silent, we give government power, and we allow them to do things to us that they would not otherwise do because we don't speak up and speak out and demand that they do it right. But when government is silent on an issue, that's an indication of its guilt because government will not debate you on an issue that they know that they cannot win. They are silent. Government can't do anything to me because if they do, they're going to bring attention to the issue, right? They can't debate me. None of these public officials can say, oh, he's wrong, he doesn't know what he's talking about, it's libel, it's slander. They can't because they're going to allow me to have the platform that I need to be able to finish this if they want to debate me on the issue. We're seeing change, guys. We're seeing change.
Do you need people in those jurisdictions and to go do presentations? Because I know you can't be everywhere at once.
Yeah, absolutely. Yeah, you can go to justicewithoutlimits.org and then sign up under Join the Movement. You'll receive emails and updates from us. We do have a lot of people that are impersonating us, so I will never reach out to you. Tano, I will never reach out to you asking for money, asking for, hey, have we sent you the affidavits yet? That's not us, guys. We only have one phone number. It's 252-940-8545. That is my only number.
And I only have a 202 area code number. That's it. There's no other numbers, guys. 202 area code number, that's it. I'm not going to give out my number publicly. I don't do that.
My number's public, so, but
she's right. I will never contact you. And more importantly, guys, we are an advocate. We speak on behalf of you in this legal matter of can a state be both accuser and judge in the same cause. We do not need to fight individual cases because every case is resolved by the one question. It is a distraction for us to come and work with an individual case. Therefore, we won't do it. We don't do it. If you guys would just get behind us on this and say, can a state be both accuser and judge in the same cause? Then guess what? Whatever they're doing to your family, whatever they're doing to you in the criminal court, whatever they're doing will be void because the answer is no. So if we can stop defending ourselves from the accusations that they're bringing so that they create something that they can arbitrate in their courtroom and we step back and we go on offense, offense looks like this. State, you're breaking the law when you bring an accusation against me and judge it. Follow the Constitution or you have no grounds whatsoever to do anything. And anything you produce is void. Refer to Civil Rule 60, B4. Any court that acts without personal or subject matter jurisdiction produces a void judgment, and a void judgment is always and forever void. It can never become valid because a court can never obtain jurisdiction when it lacks jurisdiction. Everything that the state is doing against you or your family is void. Void. And void as though it never even existed, not from the time that it's deemed unconstitutional, but from the moment that the constitutional obligation was breached. The moment that the state took action against you in a case in which the state itself was a party, void. Everything they did.
And
you get behind that and we can win this all together.
That's why I'm confident that all of these children, even if they've already been adopted out, they're coming home. I think that they're coming home.
But do remember, every single prisoner is someone's child. I don't care the age of the child. I want every single child to get back with their family, and I want them to get healed. That's why I'm fighting on the prisoner side. That's why Jessica's coming in with the younger children. We are fighting for the family and children. Every single thing we're doing has to do with children. I don't care what anybody says, right? I don't care the age of that child. Every one of them has a mother and a father, and they want their children back home too. Yeah. We're going to stop this mass breakdown, destruction of the familial unit. We're going to restore the family. We're going to get every child, every single one of them back home to their family so that they get the love and support they need so that America can heal from the traumatic institution that we call justice.
Let me get a little clarification on that, because some people that would just catch that little sentence that you made, that little paragraph, that you are not trying to release every prisoner in incarceration. That includes serial killers, rapists, murderers. No, you're not after those people, but you're after the people who, like myself, I'm on parole till I'm 100 years old for my third DWI, and I'm not saying I'm a saint or I'm innocent or all this other stuff. Yes, I was an insane, crazy, foolish, juvenile delinquent who had no boundaries, and I did a lot of bad things. I paid for those things, I feel, in my own heart, and I don't feel that I should still be under the custody of the state, but that's a whole separate topic. Now,
you're absolutely right, Floyd. I would never advocate for the release of dangerous people back into society. But there's a couple caveats to that. One is that the majority of people in prison are not a danger to society. Most criminologists across the world agree, and you can all argue with this all you want, but I would welcome you to go learn a little bit about criminology if you want to argue this. Most criminologists across the world agree that only about 4% of our prison population is a danger to society. That's the serial killers and the murderers, the things that you're talking about there, the ones that are truly dangerous. Of the remaining, 78% of them never hurt anyone except for themselves. Drug-related offenses. 78% of people are there on drug-related offenses. That's not a dangerous person. That's a hurting person. That's a person that's full of trauma, and you deal with trauma differently than you deal with danger. Danger, you need to protect society from. Trauma, you need to get them into a facility where you can heal them from what has happened to them. It's a matter of morality not being a matter of punishment and debt, but morality being a matter of public health. So what I'm saying is that we're going to shift our perspective on these individuals. We've got to stop looking at what the people do, and we've got to start looking at what was done to the person. Because when we look at what they do, all we see is a monster that needs to pay for things they've done. And that creates this vengeance-based system that we have in place today. But when we look at what was done to them long before the crime, as a child, as a husband, as a mother, then we see that something tragic happened to that person that changed the trajectory of their life, and it wasn't their fault. And now we can see the reason why they've done things they've done. Now we want to help them. Now we want to heal them. That creates a forgiveness-based system, a system that heals, which is what the system was intended to do. We were supposed to send our sinners to the church of justice to heal them. It was the place for sinners to go to get healed. And instead, in the hands of man, this church has been made to the den of robbers and thieves. This is not the institution that we were designed to have. You don't take hurting people and put them into a more hurtful situation and expect them to get out and suddenly be happy. It doesn't work that way. You take hurting people and you deal with the hurt so that they don't become a monster. Right? But the system we have today wants the monster because those monsters make them and their institution a lot of money. A lot of money, you guys. So the point is that I don't want dangerous people out. But what I do want is that if their convictions are unconstitutional, they're unconstitutional. We don't get to pick and choose who stays in or whose conviction stays valid. We don't know. We don't know who's guilty or who's not. But what we do know is that what government did was unlawful, therefore their judgment is unlawful. Government needs to identify who is a danger to society. And if it's 10%, that's fine. If it's 15%, that's fine too. But again, most criminologists across the world agree only about 4% of our prison population is a real danger to society. 78% is drug-related offenses. That's not dangerous. 78 to 96 is property-related crimes, right? Fraud, embezzlement, theft. Those are also not dangerous people. That's aberrant behavior. And you deal with aberrant behavior differently than you would deal with a dangerous person.
And a lot of times those people are hurting too.
A lot of times, yeah. So we can get a massive number of people out of the prison system by just simply saying there's a better way to deal with these people than this. Mm-hmm. For the remaining, if a person is a danger to society, I don't want them out. But we have to remove the criminal incapacitation. The criminal incapacitation. So what we have to do first off is we have to shift all of those dangerous people from a criminal incapacitation into a civil incapacitation. So we need to get them into a hospital, right? All these dangerous people, we need to get them into a hospital where we will get them the treatment that they need, and we need to stop treating a metal concrete box with guns and razor wire as the place of healing people with psychological and mental issues. We need to get them into a hospital. We need to get them treatment. We need to allow doctors to deal with the issue of morality because that's the way it's supposed to be. And if doctors determine that this person is no longer a danger to society, then great, we can deal with that. But until that happens, we're not going to address this issue of criminality. As long as the attorney generals believe that they can criminally incapacitate and take people of the United States into a guardianship of all ages, children, adults, elderly, when they believe that they can do that so they can profit off of them financially through the SQB, through the interest, through the forced involuntary servitude and for-profit businesses, whatever that might be, until we remove the Attorney General and the Bar Association from having the ability to criminally incapacitate people, take them into a guardianship so that we can profit off of them, we will never overcome this system. So the answer is I don't want dangerous people out on the streets. I don't want it. But we're going to figure out who those people are that are danger, and we're going to put them into a place that will heal them so we don't have the monster anymore. And we have plenty of countries that we can look to as examples that this works. Norway, Belgium, Israel, These countries, they chose a restorative-based justice system to heal the person from the trauma that ultimately created the monster. We're going to get rid of the monster by healing them. So that's because everybody knows a man is simply a product of the environment that he's in. If I choose to be around a bunch of abusive people, then I'm going to become abusive myself. If I and my wife if Jessica and I, we create an abusive environment and have a child, that child is going to grow up and learn how to be abusive. So when we take people and put them into a violent environment such as a prison system, then don't be surprised if we start to produce monsters as a result of the trauma that we ourselves are creating by the environment that we're placing them into.
Absolutely. So my own personal experience, I've been to prison 3 times. The first time was in 1982. The second time was in 1987. Third time was in 2002. So I've seen the evolution of the prison system and exactly what it was when I first went in the first time, that original shock, the testing that they gave us, and then how that has not improved at all through the decades. Basically, they give you a test. They want what's called your education equivalent. So they want to know what you test at as far as what grade you should be, even though you may have a GED or high school diploma or just a dropout. Then they take your IQ test. Now, my first IQ test was a 130, I think 137. My second one was 131, 132, something like that. And then the third one I took in 2002, it dropped off the scale. I was down to like 110 or something. And what was really strange because I was a jailhouse lawyer, a writ writer, these guys would bring me their case. Hey, Floyd, can you do my appeal? Can you do my writ habeas corpus? Can you do whatever? And I'd be talking to these folks or they'd bring me their disciplinary case, and their disciplinary case would have their EA score and their IQ. And that would be the first thing I'd look at. Okay, how smart is this person? And I'd look at their IQ, and their IQ would be like 166. And I would look at them and go, there's no way this person's above genius level. Absolutely not. So I knew the testing was flawed at that point in the system, because I'm interviewing people who have 40 points more than me in their IQ, and they're dumb as a box of rocks. I mean, they can't barely find the law library, much less, do any kind of legal research. So I knew the system was flawed. But back when I first went in, I was like, man, this sucks. This isn't, this is no rehabilitation. Because the first time I was there, I ended up living with one of the most prolific serial killers in the state of Texas, David Owen Brooks. We were in the same dorm. We were in this craft shop together. He was the bookkeeper in the food service department, and I was the butcher. So, yeah, I mean, I've been around these people, and I get it when you talk about people that are a danger to society. I was actually labeled, I'm almost quoting, Mr. Tarvin, you're a danger to the citizens of Harris County, Texas. Therefore, I sentence you to a term not less than 60 years in the Texas Department of Criminal Justice Correctional Institution Division. Sheriff, take him into custody. Yeah. And that's how that went down. So I know for a fact that they are not properly vetting people, whether or not they have any type of mental health issues or any environmental issues that will substantiate their criminal activity, whether they've been an alcoholic, they've been a drug abuser, a drug addict, or they were physically abused as a child, or they were sexually abused as a child, or they were in a human trafficking ring, or their mom just traded them for crack, things like that. I've experienced people that have gone through this stuff. Johnny Winters, the late Johnny Winters, not Johnny Winters, the guitarist, another one, he was from Wichita Falls. He worked with me in the bundle room, which is the showers. And he told me, man, Floyd, when I was growing up, and he was a little bit older than me, so he'd probably be in his 70s. He said, when I was a kid, it was a fight in the morning when we all woke up because there were so many kids. We had one cereal bowl. So we had to fight over who got to eat breakfast first. And then you had to wait in line to eat breakfast because they had one bowl. That's how poor these people are. So I know this, and I've experienced it. So we have to change the way the criminal justice system works, how we vet these folks who may or may not go into the system. We have to vet them before they get into the system. We have to test them, find out exactly what is wrong with them. Why are they a dysfunctional person in society? And we have to remediate that, whatever that looks like. If we continue to send these people into prison, and, if you're, a youngster, you're going to get sit what we call warrior farms. You're going to go in there and you're going to get tested every minute of every day, whether you can hold your own or you're going to get turned out as a punk.
Yeah.
You're going to be a prostitute, and you may get passed around. You may get bought and sold, traded, bartered, whatever. And that's just what the system produces. And some of these people come out even more traumatized than they went in. And then they become recidivists. They just cycle through the system. When I was on the WIT unit, I had, let me finish this. I had one guy, he came in there 4 times while I was doing my sentence, cycling through, doing these little, minor offenses, but he was cycling through the system, and that was his way of life. He would get out, go out on the streets, hustle, get convicted, come back, get what we call rescued, because the streets are so hard on him. Now he can fatten up, get free food, free meals, free medical, free everything, and then go back out on the streets on parole or discharge and reoffend, do the same things, and come back and do it over and over. And this is the system, folks. I've lived it. I've breathed it. I've experienced it. Go ahead.
Yeah. So hurting people hurt people. I mean, that's the general basic knowledge. So, the reason why one human being has no respect for another human being is because they have a lack of respect for themselves. I mean, you can see in criminology, at least, the most violent people within our society, the ones that we say are the worst of the worst, they themselves are victims of heinous crimes against them that are so bad that they wouldn't even be what we can conceive as child abuse. And this is well known that serial killers and these people that have no respect for human life were they themselves victims of heinous crimes against them, crimes that we would not even we wouldn't even conceive or comprehend as child abuse, because it's so much worse. This is well known, but we can also say that when you have a person respect themselves, that respect overflows to others. So, once again, when you deal with the trauma of the individual, of the child, you deal with what happened to them that made them say, I'm worthless, I'm garbage, throw me away, just like my mother and my father did, or whoever else. When we deal with that trauma and we show that you're worth, caring for and taking care of, then that respect for self becomes what they use to actually respect the life of others. And again, this is well known. There are lots and lots of nations that have gone this direction as examples that we can use for our own justice system. We don't take into account what happened to that person long before the crime. We only look at what that person did, and we're looking in the wrong direction, because the person, right, was not born to be a monster. None of you delivered a monster, when they were born. All you mothers and fathers that are losing your children, your child was not born a monster. The system is making them become a monster from the trauma that the system is inflicting upon your child through the destruction of the familial unit, what we're trying to fight here. So we don't want your child to be punished for what wasn't your child's fault, right? What happened to your child was not, it wasn't even your fault. It was a system that wanted to profit off of the destruction of the familial unit so they could put them into an institution and receive federal funding or force them into involuntary servitude for the direct benefit of the state, because it's enslavement. And the slave owner is now the state. The monster isn't born. The monster is created. The person was born. Your child's a person. And that person deserves to be treated and taken care of and loved, because that's what God created for them to have in order to become the person that God created them to be. So we want to take the monsters, we want to bring them back to a person so that the monster doesn't exist. Because if we can create the monster, then that means that we can also decreate it. And that's what we're proposing here. More than anything else. I don't want dangerous people out in the streets. But I also don't want your children, the 12 million children that have been stolen from mothers and fathers across this country, I don't want those children to grow up and be thrown into a system labeled a monster and have everybody think that you did nothing but deliver a monster into this world. That child was not a monster when they were born. You don't want them to be thrown away. But yet if we don't address this and address the trauma in the individuals, even knowing that we may not be able to fix this generation, this might be one generation out. But if we put into place today steps so we can have a better tomorrow, right? A more stable and firm familial unit tomorrow. If we can take those steps today, and if that requires, that we do have a max exodus of the prison system, that we establish programs and solutions that's going to heal people from the things that have happened to them, then by God, let's do it. So that your children, right, and your children's children do not have to experience what we ourselves have now experienced all across the country. 24 million parents have had their children stolen from them. That's trauma being inflicted upon adults, parents that are turning to drug use and then being a product of the system. That's children that are growing up without love and not knowing who they are, and now they're feeding into the system. We've got to stop and say, let's put into place steps today that's going to get the solution that we want tomorrow. And that's going to require a mass forgiveness of sins. It's going to require us to look at these prisoners differently than we do today. And it's going to require us to stand up and fight for them and their rights, because that's the only way that we're going to get all of our rights back. So anybody that wants to know what I'm proposing for my remedy, my proposal for this solution, what I want to see the people of the United States actually do, and what I would propose as a solution to this problem, I would welcome you guys to go out to my TikTok page. It's Tanawa Downing, at Tanawa Downing. Go to my TikTok page, and up at the pinned videos, there's 3 pinned videos on my page. One of those pinned videos is about a 15-minute video, and it explains everything that I would propose to fix this problem. It may not be the best solution, but it's what I'm proposing to the people of the United States. It's what God has put in my heart as a solution to resolve this. I would love to go through it, but I would never do as good of a job as I did on that particular interview that day. I would welcome you guys to go out, watch that video, and I'll go ahead and I'll repost it today onto my Facebook page as well. So it'll be there. It's my proposed.
How many followers do you have on TikTok now?
I have 34,000 I think on TikTok.
And he only has one account.
One account.
So any other account that pops up when you search Tanawa Downing, it's not him. Over 30,000 followers.
Yeah, at 34,000. I only have one Facebook page, one TikTok. I don't set up other accounts. I don't have other names. I have one account, guys.
Same
one
for
account.
me.
I don't have backup accounts. I have one account.
Same for me.
Yeah, please be careful out there when you're espousing the truth and you have an audience. We get taken advantage of by people recreating false social media profiles. So y'all be aware of that.
I'll tell you what, Floyd. They've stolen tens of thousands of dollars from people. They've stolen a lot of money. They've stolen a lot of money, a lot more money than we get. So, So the last thing, the last thing I would say is that guys, we still need donations. We operate on donation only, and the reason why is because we're not an attorney. I can't solicit you for work, and I can't make a promise to you that I'm going to come to your city and do your case because that's not what we're doing. I've explained during this show what we're doing. We are fighting literally the biggest civil rights case in American history. The TERS motto is one question, one action. Every prisoner, children, adult, doesn't matter, every prisoner, we have one question, guys. can a state be both accuser and judge in the same cause? We're going to bring one action, right? And once we bring that action, this will result in the release of every prisoner. Now, when I say release, we're talking, once again, release from the criminal enslavement that has come upon them. We're not saying get them out into public, but we are saying that you are going to address this issue of enslavement, and we are going to destroy this slavery institution once and for all with finality. So
Right.
we still need donations. We only operate that way. We're going to have another decent week right now. We're going into Washington, D.C. next week for the toll and roll. We're going to be there working with Blue Man Fleming and some other people. I promise you, I give you my word, I'm a man of my word, we will not stop until this is done. I know what I need to do to continue to push forward. I know that there's a second half that I don't have control over, but that second half, we will reach that point because we're not going to stop until that court has conceded and agreed to finally hear this case and stop ignoring it.
Wow. All right. I have about 3 minutes left for within 2 hours. Anything either of you two would like to close with?
Go ahead. I just closed. I'm done.
He's the closer. I just want to encourage the families that are out there. I get a lot of messages from parents that are just saying, I've given up, I can't go on, and I just want to encourage you guys. If you give up, they will absolutely win. They will forever have your children, and your children will become part of their statistic for financial gain. And that's it. So do not give up. That's the worst thing that you could do. Take some time if you're in that state of deprivation, and I get it. I mean, I haven't seen my kids or talked to my children, my son since March, and my daughter since April as well. And almost every single day I tell Tana, I want to see Wyatt. I want to see Adeline. And so, I'm out here dealing with those emotions as well. And I think that a lot of people forget about that. Nonetheless, try your best to take care of yourself. What you eat matters. How much sleep you get matters. Whether you take time for yourself just to revive and recuperate. Remind yourself that you are strong. Why are you laughing at me? Because I have been
This is
trying
my
to
advice
get
to her,
Tana
and she is clearly
That's
not taking
not
my
true.
advice, just passing it
Look,
on to you.
No. I have been asking for him to go work out with me for quite some time.
I like being fat.
Anyway, try to
Good for you, Jessica.
try to keep your physical, your mental, your emotional health intact, because I think that 2026 is going to produce a lot of what we have all been fighting for the previous years. And it's not one of those things that I know, but I know. I just feel it. I feel like this is the year. We have the midterm elections coming up. There are some people that are running for election that have not previously held any type of position of power that we're going to get behind, and we'll start releasing that information and kind of working with them as well, because we think that if they can get into some type of legislative power, they will start pushing this agenda. Pushing the agenda for even altering and amending the Constitution in a manner that is consistent with familial rights. Like, that actually needs to be amended, and we need to have family rights included into the Constitution, so we're not having to try to fight with all of these sidebar arguments. And so
The
there's
Supreme
a lot
Court
of
created
things.
the right. Now we need to enforce it through law.
Yes.
And that's where we missed it.
Yeah.
The legislator must create a law that obligates and enforces the right. Absent that, we don't have it. That's what we're working with DC on now.
Yeah.
On the familial unit. But remember, we already have the obligation in the criminal matter. We're already there with the indictment. So
Yeah.
30 seconds. I've got to
So
go.
I think 2026 is going to be a big year.
I'm interviewing Carmen Maria Montel. She's running for the 18th U.S. Congressional District on Monday.
Awesome.
I will put this bug in her ear.
Please do.
Absolutely.
Yep.
Thank you, Tanawa, Jessica. God bless you. Safe travels.
Thank you, Floyd.
Hey, Jesus Christ, our Creator, please protect Tanawa and Jessica out on the road. Amen. There you go. I got to go. Thank you. Y'all go watch your show here in a minute.
God bless.
Okay.
Thank you. Thank you so much, brother. God bless. We'll talk to you here later, brother.
Yes, sir.
How do we exit out of here?
All right, guys. I'm not
How do
sure.
we exit out of here? There we go. Okay.
All right, guys. It's 3:00 Eastern right now, so an hour and a half. We're gonna be on Zoom. I'm gonna go over Second Amendment and how that applies to what we're doing. And no, it's not about guns. So sorry. Anyway, I'll go through. And answer
Are there
some
any
of these
questions while we're sitting here?
Let's see. Let me see if we have questions. Hold on. I'm sorry.
So there's an old saying, when you rob a man of all he has, you made a man with nothing to lose. So for years and years and years, I've had nothing. God took it all away so that he could teach me how to rely upon him and trust him. And the only way I could do that is by taking everything away. But there comes a point in time when, in order to actually fight for something, you also got to have a reason to fight. So I want to say that I'm very thankful that God brought Jessica into my life here because she's the reason why I'm fighting now. She's what's given me the strength to actually finish this, because for years I was sitting here and I didn't have anything to fight for. I understand my kids, yes, but when those were taken from me years and years and years ago, I lost the thing to fight for. I'm fighting for the kids once again. I love them. I miss them. But God had to bring something into my life worth fighting for once again. And I thank him so much for bringing her in.
Aww.
Giving me a reason to fight.
You're gonna make me cry.
Yeah. And get fat too. Reason,
I
get fighting fat.
I didn't pay him to say that.
Yes, you did.
No, I didn't, because that would have been all of their money. Anyway, let me see if you guys have any questions that I missed and you want to put it into the chat now. But we are going to be on Zoom in an hour and a half. If you did not get an email, it's because I ran out of emails. We had to pay for an email service because we're sending out over 40,000 emails a month now. And so if you didn't get the email, go to justicewithoutlimits.org. The Zoom link and how to get on is right there. You just click on it and hop on in an hour and a half, right at 4:30 Eastern.
Jamie,
So
I do want to say I got your hat out too. So if you're on here, Jamie, I got your hat. Thank you, brother. I know you've been concerned about my beer toss hat. So today we're sporting a new one.
looks good. I like it. All right.
Guys, if you guys want to continue to see us do what we're doing, please donate. Please keep those donations coming in. You guys have been amazing. You guys have really made it really easy for us the last couple months.
Yeah.
Especially, you guys are just awesome. You know, you guys have allowed us to be able to operate freely. And what I want you guys to know is that one of the reasons why I operate on donation only, and I have for 9 years, is because at any given moment, I want to make sure that I'm doing what God needs me to do. If I were under a contract to perform, I would be limited in what I could do every single day. I know every single day that I wake up and I do what's necessary to overcome, this injustice and to serve all of you, right? But that can't come from specific individual obligations. The obligation that I have is to God, and He's making sure that through all of you, we have the resources we need to be successful. Just want to say thank you guys so much. You guys have really blessed us and kept us from having to worry about where we're going to sleep or what we're going to eat. You guys have been amazing, and it's been incredible. So thank you guys so much. Please do continue to donate so we can continue to get this done. I also believe 2026, this is the year. I believe it's every year. It's for 9 years. I believe that this is the year. But right now, I think 2026 is the year. The momentum that we're building is so big. The questions, the people that are coming to us, guys, they're running scared right now. They're absolutely running scared on this, and we're hearing it. I mean, we sat down with the judge this week, and the judge said to me, "You're absolutely right. Yeah. You're right."
And He's behind us. He's behind us, guys. I was going to say something. Oh, Birmingham. I haven't uploaded the video for Birmingham yet, but after we served, he provided the notice, left it on the counter, and I tossed the affidavit onto the table. Nobody would touch it. They were all standing around taking pictures of the front of the notice and the affidavit, but nobody would touch it. Now that doesn't matter. They were all served, but that just goes to show that, one, they know exactly what we were doing, and they know that they have a duty to act. And none of them. It was like, it's like we delivered a snake in there. I mean, they just they were literally dancing around these papers that we left. It was so comical. I gotta get the
multiple
video up.
people, and they were all sitting there on their phone talking to some attorney or counsel, trying to say, what do we do about this? And what's funny is that Jessica was videotaping them from outside the room, outside the door through the window. And when they turned and looked and saw Jessica recording, then they all just kind of, did one of those, where am I at?
We're not
it was
looking at
they
this.
caught her videotaping and taking pictures of the notice. And then when they realized that she was videotaping them, they just kind of went, oh, well, looking away. Don't know what I'm looking at.
That's
So
hilarious.
that's power, you guys. That's power. We have these people are scared of what we're doing because they know we're right.
These comments are going so fast. I just asked someone how can I get onto the Zoom? Go to justicewithoutlimits.org. The Zoom link is right on the top of the homepage. I also saw several different people asking about what motions do you file. Guys, we can't tell you what motions you have to file. Now, I do make my motions public. Most of my motions, especially my motions that I've released on Facebook, if you want a copy of the motions that I filed, I'll be happy to give it to you. It's all public record anyway. You could go to my case and get the motion, so I have no problem, relieving you of that and trying to get my motions. But if you want to see my motions and stuff that I filed, you're
Guys,
more than welcome to have them.
So there is no motion on this. Can a state be both accuser and judge on the same cause issue? There's no motion that you guys can submit. One, because this hasn't been litigated yet. We have to finish I have to finish litigating this on your behalf, right? On behalf of people in the United States. But you got to understand that the Article 3 issue, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. That means that when a state is a party in a cause, the Supreme Court of the United States has personal jurisdiction to oversee the case, right? Because they are the only court, the first court to take action when a state is named a party. So if you were to submit a motion to your state court and say, hey, you don't have jurisdiction, well, they do claim jurisdiction because the Supreme Court of the United States is permitting them to have jurisdiction. The obligation exists with the Supreme Court, right? So we have to, today, every single one of you have the right to take your case to the Supreme Court of the United States because the Constitution has the obligation placed upon that court to oversee your case. The problem is that before you can claim that you have a right, you must first show that someone has a duty. The duty derives from the law. That's why I'm law enforcement. That's why what I'm doing deals with how do we get your right to manifest. You have the right to be heard by the Supreme Court of the United States because the Supreme Court has the obligation, the constitutional obligation to do so. But before you can file a motion and claim that your right has been violated, I first have to show that the Supreme Court has a duty established by law and that they breached that duty. Once I do that, then it will give you the power to then go into your local court with a motion to say, court, you don't have jurisdiction, or a judgment. Vacate the judgment because the judgment derives from a court that didn't have jurisdiction, or the adoption. The adoption is void because the court didn't have jurisdiction. Whatever it is that they're doing to you, you will be able to address that once I go to the court that has jurisdiction and show that they have a lawful obligation. And once I show that they have a lawful obligation that they breached, because the state does not have the authority to oversee its own case, because the Constitution doesn't grant the state jurisdiction. So the issue is that you guys need to push me into that court. Once I'm in that court, I will litigate it for the people of the United States, and then I will send down help from above in the form of a decision that all of you will be able to place into a motion to vacate whatever action the state has taken against you or your family. So there's a course of action that has to happen. There's certain steps. You will get nowhere filing a motion with your court, because as of today, the Supreme Court of the United States does not realize that they have a lawful constitutional obligation. I have to go to them, show the obligation, and that they have not fulfilled the obligation. And when I do that, then you guys will have the power that you need to file the motions that are necessary. But those motions, those will come once we finish this, right? Once we finish this first step, we show that there is a lawful obligation and that obligation has been breached. In other words, the law has been broken. Then you guys will be able to claim that your right has been violated because your right derives from the Supreme Court's obligation that's constitutionally codified. This is a matter of all of you, for me, all for one, so that I can provide one judgment down to all of you. All for one and one for all. One action, one question for all prisoners. Doesn't matter all prisoners. Child, adult, doesn't matter, okay? One question, one action, every prisoner. We only need one, okay?
I saw Daniel say something about how do you get a copy of the bond. I just called the clerk of deeds, I believe, in Tennessee. That's who holds that. And so I got a copy of the surety bond for the sheriff and some of the other county. It's only the county level officials. The judges so far haven't been able to hunt down whether they do or don't have a bond. They're supposed to, but that's something that you might could do in your local county. All right, guys, I've got to go. It's 3:11. I need to go get set up for the Zoom here in an hour and 20 minutes. So I'm gonna hop off. I love you all. Stay strong.
I don't know if anybody's asked donations, because you guys usually ask. Go to the website.
Yeah.
The website, justicewithoutlimits.org.
Drop down menu.
Drop down menu.
Donate.
And from there you can get to the exact donation points. For those of you that do know, it is Chime, Cash App, Chime, Venmo, PayPal. They're all exactly the same. We shall be free. WESHALLBEFREE. We shall be free. Those are the only ways, other than her Zelly, but you can get that off the website.
Yep.
So anybody, if you want to just make sure that you got the right, go to the website, donate through the website, and do not get scammed. We will never, ever, ever send you a message asking you to give us money. Never do it.
And even on some of these other apps, like on Cash App, they have "We shall be free" with 3 E's at the end. So if you accidentally click the 3 E's, and they are using his logo. So "We shall be free" with 3 E's, and then "We shall be free" with a dash, and there's some other, fraudulent things that there. So just go to the website just to be safe, so that you're not sending money to someone that's trying to harm all of us anyway. So that's
Look forward to seeing you guys out on the road.
And I look forward to seeing you all in an hour and 15 minutes on Zoom. Bye, guys. Love you.
All right, guys.
Talk to you
God bless
later.
everybody. Thank you so much.